our law clinic. I'm joined here today with Mackenzie and Lori, and we will be talking about trade secrets and patents. This presentation will be available on our website in a couple of days after the presentation. Please note that although this presentation is offered to everyone, our clinic services are offered only to BU and MIT students. We also ask that you hold all the questions until the end of the presentation. So for today's agenda, we'll first be talking about trade secrets, what trade secret law protects and how to get protection. Second, we'll talk about patents and how patents protects inventions. And lastly, we'll walk you through that patent application process.
So what are trade secrets? A trade secret is any information that derives commercial value from the fact that it is a secret. It's a secret that its holders take reasonable precautions to protect. Trade secrets can be things like business plans, customer lists, product designs, recipes, even algorithms. And just from hearing those types of examples, you might be able to see how someone could derive a competitive advantage by keeping such information a secret. Let's get into what they can do for you. Trade secret law gives you the right to prevent certain people from misappropriating your secret. Misappropriation in this context refers to someone acquiring the secret through improper means. So namely the types of people described in the bullets. Looking at the first bullet, trade secret law protects you from people who obtain your secret through improper means. These are your people who acquire the secret via theft, espionage, or misrepresentation. Underneath that, you have protection from people who disclose without consent of the owner, but they have to know or have reason to know that it was a trade secret and that knowledge of it had been acquired by accident or mistake. And similarly, you have protection from people who use without the consent of the owner. But same deal here, they have to know or have reason to know it was a trade secret and that knowledge of it had been acquired by accident or mistake. So one who discloses or uses another's trade secret without a privilege to do so is liable to the other if they discovered the secret by improper means or their disclosure or use constitutes a breach of confidence to the owner. But there are some people that it won't protect you from. The first type is independent inventors. So let's say person X and person Y independently invent the same thing. Trade secret law can't protect them from each other. The second is reverse engineers. Let's say person Y buys person X's product and takes it apart to figure out the trade secret. Trade secret law can't protect person X from this. This could be cause for concern. Why does trade secret law allow this? Well, intellectual property law in general strikes the balance between the protection of ideas on one hand and competition that could spur innovation on the other. Plus, if a secret can be easily reverse engineered in spite of reasonable precautions, it begs the question of whether much value can come from the trade secret to begin with. The final thing to consider here is inadvertent disclosure. So earlier you heard me say trade secret law will protect you from people who acquire a trade secret by accident and disclose without permission if they knew or had reason to know that it was a trade secret. Well, the flip side of that is if the unintended recipient of a trade secret uses or discloses and they don't know that it's a trade secret, no liability will exist for them. And in that case, notice should be given to the recipient promptly after learning of the inadvertent disclosure. So whereas the last slide describes some improper means, these situations would be considered proper means in which to obtain a trade secret. So how do I get trade secret protection? Well, you treat it like a trade secret. There are no paperwork formalities required. Trade secrets just exist until they're not a secret anymore. So how do you treat it like a trade secret? Well, you make sure it's a secret. Ask yourself if it's not generally known. Similarly, you would ask yourself, is it not readily ascertainable? Or in other words, make sure it's not something that's easy to figure out through proper means. Third, you have to draw value from the fact that it's a secret. So does it give you a competitive advantage of some sort? Finally, you need to take responsible precautions. Here you want to ask yourself what steps you take to protect it. We want to give you an idea of what some good precautions are when it comes to safeguarding information. Administrative precautions typically concern the policies and procedures you use to manage security measures, and we have some examples here on the slide, starting with NDAs. NDAs are non-disclosure agreements that outline confidential information and protect that information from disclosure. Moving to contingency plan. Having a contingency plan is always a good idea. For example, if an email containing trade secret information goes to the wrong person, you should immediately follow up and ask the person to delete the email because it contained confidential information. There's no guarantee that merely following up would protect the secret, though. So to take it a step further, it'd probably be safest if the person responds and actually says they understand and will delete the email and then actually deletes the email. So at the end of the day, you need to be really careful because those types of mistakes can be pretty detrimental, and there definitely should be a procedure in place. Going down to restrict access. Controlling the amount of people who have access to the trade secret reduces the chances of the secret being compromised. And finally, review your policies. It's a good idea to regularly do this in order to make sure that the precautions you've implemented are effective and that the people on your team are aware of them and using them. You can also implement physical precautions. So evasive design. If your product is a physical one, utilize a design that won't easily be undone through reverse engineering. Information disposal. Consider how you dispose of documents containing sensitive trade secret information, so outsiders won't get the information after you throw it away. Next, look at security guards. Maybe you want someone on your team whose sole job is to watch over security measures. And the last one is pretty self-explanatory. You could use a lot. Finally, you can also use technical precautions. And here we're talking about technology and related policies that protect data from unauthorized access. Digital locks. If you don't want a physical lock, maybe consider a digital one. You can use a digital barrier. You can put up a digital barrier around your network using firewalls, and using encryption, you could scramble information to protect it from outside eyes. Maybe you want to use a private network, which is yet another way of restricting access to sensitive information. And this may seem like a lot, but remember that the rule is not that you have to have perfect precautions, but reasonable ones. So what you implement will end up being a balancing act. These are just some ideas to get you thinking about what you can do and what works for you in your situation. We have a hypothetical situation here to help ground the information, and I'll read it to you. Weasley's Wizard Wheezes created a new line of products made to help students improve studying habits. The potion, named Study Buddy, gives the drinker 4 hours of energy while also preventing the drinker from moving off the chair. And here's the question. If the Study Buddy is treated as a trade secret, which of the following events will not be protected? A. Hermione buys the product, takes it apart, and recreates her own version to use. B. Harry signs an NDA and helps test the product in initial stages, but then leaks how it works, knowing it was a secret. Or C. Malfoy illegally spies on the Weasleys day and night until he uncovers how to make the Study Buddy. So if you would, please put the answer you think is correct in the chat. Right. Okay, so looks like you got the idea. The correct answer here is A. It's an example of reverse engineering. And trade secret law does not protect against that. So I'll go ahead and explain the other answers as well. And B, Harry disclosed the trade secret without permission, knowing it was a trade secret and it constituted a breach of confidence to the Weasleys, which is an example of improper disclosure. And C is an example of improper acquisition. Illegally spying in order to obtain a trade secret is acquiring the secret through improper means. So two more things about trade secrets. Note that with trade secret, you do not disclose what the secret is in order to get protection. And also, Once it is known and the secret is out, and there's not really much you can do to put the genie back into the bottle. And with that, I will now hand it over to Lori for patent.
Thanks, Mackenzie. So now we're going to be talking a bit about patents. In the next few slides, I'll be going over patents generally and how they protect inventions. Joanne will later walk you through the actual process involved in obtaining a patent. So let's get into it. So what is a patent? Patents give you the right to exclude others from making, using, offering for sale, or selling the invention in the United States or importing the invention into the US. So in other words, the patent doesn't give you the right to make, use, offer for sale, sell, or import your invention, but it gives you the right to exclude others from doing so for a general period of 20 years. And before you ask, yes, that is a real patent for a substance dispensing headgear. It can seem like you can get a patent for almost anything, but there are actually some hurdles that you have to clear before you can get a patent, which I will go over in this section of the presentation. Like I mentioned in the previous slide, the patent gives you the right to exclude others from making, using, offering for sale, or importing your invention into the US. And an often used visual explanation for representing how a patent functions is likening it to a fence. So you can think of the patent as a fence that sets up a perimeter around your invention, and you can keep other people out. You can still license your patent to let other people use it, but the patent gives you a monopoly and control over the invention. So unlike a trade secret, which Mackenzie talked about earlier, even if somebody independently came up with your invention without any knowledge of your patent fence gives you the right to exclude those independent inventors from your patented invention. So in this slide, I'm going to give a brief overview of the different categories of patents that you can obtain. There are 3: utility, design, and plant patents. The utility patent gives you the right to exclude others from making, using, and selling the claimed invention, and it lasts for 20 years from the date of filing. Design patents protect the way something looks. For example, the design of an iPhone can be protected by a design patent. This patent works like a utility patent in that it acts like a fence to exclude others, but rather than preventing them from making, using, or selling the invention, the design patent prevents them from making an object with a design that is substantially similar to the design covered in your patent, and these last for about 15 years. They even have plant patents. So these are for plants that aren't naturally occurring, and it protects a new and unique plant's key characteristics from being copied, sold, or used by others. And it helps the inventor of the plant patent secure higher profits by preventing competitors from using the plant for a period of 20 years. So although the patents have different applications, the underlying theme of all 3 is that they give the patent holder a monopoly over whatever the patent protects. Again, this is distinct from a trade secret, which does not protect inventions created independently through methods such as reverse engineering. And on this slide, we have examples of what the different patents look like. On the top left, we have a utility patent for sled pants. On the bottom left, that's a design patent for an iPhone. And on the right, we have a patent for the universally acclaimed Haas avocado. And looking at this slide, it can seem like you can get a patent for almost anything. However, like I mentioned before, there are certain legal hurdles that you must clear before you can be on your way to receiving a patent. And so let's talk about what some of those are. So there are a few things to consider before you start knocking on doors and asking for a patent application. To qualify for a utility patent, which is the type of patent most of you are likely interested in, your invention must be patentable subject matter, useful, novel, and non-obvious. Your invention must be able to clear all 4 of these hurdles during the U.S. Patent and Trademark Office, the USPTO's, examination of your patent application in order for your invention to qualify for a patent. So these are often technical elements that your patent attorney can offer a more in-depth analysis for, but I'm going to give you a brief overview of what each of these elements are to give you a better idea of what they cover and give you a general lay of the land. So let's get into it. The first hurdle that I spoke about was patentable subject matter. So one of the first hurdles your invention must overcome is whether it is patentable subject matter. So things like processes, machines, an article of manufacture, that is anything made by a human, composition of matter, and improvements to any of the aforementioned items are considered patentable. However, there are things that are considered categorically unpatentable. So things like laws of nature, for instance, you can't patent gravity, things that naturally occur, naturally occurring products, physical phenomena such as characteristics of naturally occurring bacteria, and abstract ideas like mathematical concepts are not patentable. And this reflects the patent law's attempt to strike a balance between incentivizing innovation by offering a monopoly to anyone who invents something novel, and at the same time, not wanting to tie up people's ability to innovate. For instance, if somebody patented an important mathematical concept, no one would be able to use that mathematical concept for 20 years of the patent's duration without the patent holder's permission. And as a side note, things like literary, dramatic, musical, and artistic works, on the other hand, are not patentable and should be sought to be protected under copyright. And just to illustrate each of these elements a bit better, I'm going to use a lovely patent for a very useful animal ear protector. The animal ear protector here would be considered a patentable subject matter because it would fall neatly into that article of manufacture category. Of course, having a patentable subject matter is not the end. There are those 3 more hurdles you must clear if you are seeking a patent for your invention. Remember, your invention must also be useful, novel, and non-obvious on top of being patentable subject matter. Usefulness is a relatively low bar to clear. You have to articulate some sort of use for your invention. For example, here, the animal ear protectors could be considered useful because it protects the animal's ears. It's as simple as that. Third, your invention must be novel. So novel means that the invention must be new. That is, nothing just like the invention can be found in previous inventions or known to the public. More commonly, an inventor may end up accidentally destroying the novelty of his or her invention if he discloses this invention to the public. And in the US, an inventor has 1 year after public disclosure to file a patent. After that 1 period is up, public disclosure may be used to reject the invention's novelty, even if it was the inventor himself who had disclosed it. How much disclosure is considered enough to destroy novelty is a question that we often get. The standard that they use at the USPTO is enabling disclosure, which means that enables somebody skilled in the arts to practice the invention. This is something that you can also speak in more detail to a patent attorney about. And just using the animal ear protector here as an example, let's say that the Weasley twins, going on our Harry Potter theme, invented the animal ear protector over the weekend, and they were so excited about their invention that they made an announcement about it to the entire Great Hall during dinner, and they told everybody how they built the animal ear protector. As soon as they make that announcement and pretending that the US patent law applies, the clock starts ticking, and they would have 1 year to file for their patent, or else their invention will no longer be considered novel. And just as another note, public disclosure can get a little tricky sometimes, and it can even include telling a close group of friends about your invention. Again, this is something that you can consult your patent attorney about. Your patent must also be non-obvious. That is the 4th hurdle. So non-obvious means that something is not readily apparent. So an invention is considered obvious if somebody of ordinary skill in the relevant field could easily make the invention based on prior art. Prior art is invention that is publicly available before filing your patent. Is information that is publicly available before you file your patent. In other words, your invention will not clear the non-obvious hurdle if the USPTO deems that it had been obvious for somebody in the relevant field to use the existing knowledge to come up with your invention. Again, using the animal ear protector as an example, let's say there was prior art or knowledge in the field of dog products about strapping things to a dog's head and some sort of device to keep a dog's ears out of its face. The USPTO may find that the animal ear protectors was an obvious invention and not patentable. I use may here because the non-obvious analysis can also get a little tricky sometimes. Again, because it gets so technical, it's something that a patent attorney can give you a lot more guidance on. So as a quick overview, the 4 hurdles your invention must clear in order to receive a patent are: it must be a patentable subject matter, it must be useful, it must be novel, and it must not be obvious. Before moving on and passing it off to Joanne, I do want to talk very briefly about open sources and patents because it is often a big component of startups. It's hard to get software patents after a Supreme Court case called Alice, which clarifies that software shouldn't be patented if it's just an implementation of an abstract idea, but it is possible to get a software patent if it can be shown that the applied for invention isn't an abstract idea. For example, a method of computerized risk mitigation in financial settlements would be considered an abstract idea and ineligible for a patent because risk mitigation would be considered a longstanding fundamental economic practice. So because it's an abstract idea, you can't get a patent for it. Another speed bump you may hit in trying to receive a patent for a software is if you're using open source software. If you're using open source software. So as mentioned before, patents are meant to exclude others by putting a fence around the claimed invention. On the other hand, open source licensing is predicated on the idea that anyone should be able to view and use the source code. So there is a bit of tension between these two philosophies, but that doesn't necessarily mean you shouldn't get a patent for your open source software. Even if you want to distribute your software under an open source license, you can still get a patent because you may plan on licensing the patent to others to produce a revenue stream. You may want to assert your patent rights against redistributors who don't conform to the open source licensing terms. For example, those who don't redistribute for free as outlined by your open source license terms. You may want to have patent rights to use as offensive or defensive weapons against infringers who are not using the open source software. And you may plan to also distribute a different version of the software that is not distributed under an open source license. In other words, using open source software in your invention should not automatically make you discount getting a patent, even if the very concept of a patent and open source software seem at odds with each other. And so I also have a hypo that's real quick. So we're going back to the Study Buddy potion. And so just as a refresher, Weasley Wizard Wheezes created a new line of products made to help students improve studying habits. The potion named Study Buddy uses 100% juice from a mandrake, a species of screaming root found naturally in the Forbidden Forest. The process entails using a complicated machine to extract juice from the mandrake. So the question is, assuming it was not obvious to extract mandrake juice and no one had ever done this before, which part of Study Buddy is patentable? A, only the mandrake juice is patentable. B, the process used to extract the mandrake juice is patentable. Or C, both the extraction process for the juice and the mandrake juice are patentable. Please drop your answers into the chat and I will reveal the answer. So yeah, it seems like most of you kind of got it. So the answer here is actually B. The method used to extract the mandrake juice is a process and thus would be considered patentable subject matter. Because the mandrake juice itself is a naturally occurring product, it occurs in nature, it would not be patentable subject matter. So now I'm going to switch off to Joanne, who's going to talk a bit more about the patent application process.
Thanks, Lori. Okay, so now we're going to take you through the patent application process. So here we have the process sort of listed out step by step. Please keep in mind that this is a very generalized and best case scenario illustration. So the first step is to determine whether or not your invention is patentable. Lori previously outlined those factors to determine patentability. The second step is to decide between a provisional and non-provisional application. I will talk about this more in the next slide. The third step is to prepare your patent application, what needs to be drafted for you to file it. The fourth step is to then file it with the USPTO. Fifth step is to receive an office action from the USPTO. This is a official correspondence that they send you in regards to your patent application. And the sixth step is to receive a notice of approval. Seventh step is to get your patent granted. And the last step is to maintain your patent. So you need to decide, or you need to see the differences between a provisional and non-provisional application. What are they? So a provisional application requires less detail than the utility patent application. So it could be prepared by the inventor or a layperson. However, you still need to make sure you disclose any details sufficiently in that provisional application in order to get the priority date. If you don't end up, or if you end up including any new information in your provisional application, it won't be able to claim back to that priority date of the provisional application. But that doesn't mean it's all is lost. It'll just have the priority date of that non-provisional application. Provisional applications get you that patent pending status, and this helps you protect your invention and also attract investors. The provisional application is less expensive because the filing fees are a lot less, and also you could prepare it yourself. Please keep in mind that you do need to file the utility application or the non-provisional application within 1 year of filing because the provisional application is not examined by the USPTO. So those are the main attributes of a provisional application. Let's look at a non-provisional or utility application. So on the other side, non-provisional applications are examined by the USPTO. As of December of 2020, it takes an average of around 15.4 months until you get a first office action. There are other options to make this process go faster, but I'll discuss that later in the presentation. Non-provisional applications are costly. So depending on the complexity of your invention, they can easily cost up at least $10,000 for just the preparation of your application. And this doesn't include any of your downstream costs associated with prosecuting your patent application. Lastly, the non-provisional application has specific filing requirements. The USPTO has very strict requirements on how they want your application submitted. So it's best to hire a patent attorney to make sure that everything is prepared and filed correctly. So you decided on filing a non-provisional application. Now what? As part of the patent application is the specification section, and that includes the background and summary, brief description of the drawings, which goes over the different angles and views of each figure, and the detailed description of the invention. And this is the main chunk of your written portion, and it includes all the nitty-gritty details of your invention. The non-provisional application includes claims, which basically is the heart of your invention. Once the patent office grants you your patent, your exclusive rights over your invention are defined by those claims. So thinking back to Lori's fence example, the claims are represented by the fence. The broader the claim, the more protected it is, and the larger the property is within those claims. There are a lot of formalities involved with drafting the claims, such as the numbering and the arrangement. So once again, it's best to hire a patent attorney who can draft to adhere to the formalities and best protect your invention. On the bottom there, I included an example of the first claim for the Harry Potter interactive wand patent. And that broadly describes the invention and sets the tone for the protection claimed by the invention. And lastly, the application includes drawings. So I included here on the top left an example of the drawings found in that same patent application. So once the application is prepared, it's time to file it. The application can be filed online or via snail mail. You will need to pay the appropriate filing fees, which can vary depending on your entity size. You can either be a large, small, or micro entity, which have a 50% and 75% reduction in fees respectively. Our clients at the clinic will typically fall under the small or micro entity since they will likely have less than 500 employees or is a nonprofit or not have filed more than 4 patent applications and not exceed the gross income cap of around $200,000. So once you file the application, you receive a filing receipt from the USPTO, which includes your serial number and your filing date. And if there are no outstanding action items, it's time to wait. And we wanted to remind you at this point that our clinic does everything except patent prosecution. So although we can't help you with filing your patent application, we can definitely help connect you with patent attorneys on our network. So next, office action. An office action is a written correspondence from the patent examiner that requires a properly signed written response from the applicant in order for the prosecution of your application to continue. So a response is typically due within 6 months of receiving an office action. And if you use any extensions, you have to pay the appropriate extension fees. Please keep in mind that the office actions you could receive could have a shortened response deadline, such as the restriction requirement, which has a 2-month turnaround, which is a lot shorter than the other office actions. But you can pay the respective extension fees if you need more time. Additional sort of different office actions you could receive are the notice of approval or notice of allowance, which kind of leads me to the next slide. So once you receive the notice of approval from the USPTO, it's time for the issuance of your patent. You are required to pay an issue fee before receiving your one hard copy of your issued patent. Issue fees can range from $1,200 to $300 depending on your entity size. And once you receive your patent, you need to keep track of your maintenance fees. A patent that expires for failure to pay maintenance fees will expire on the 4th, 8th, and 12th year anniversary date that the patent was granted. So there are some timing considerations you should keep in mind when you're filing your patent application. So first, you need to make sure that you file an application within 12 months of public disclosure in the US. So Lori previously discussed this, but as a refresher, a public disclosure could include things like a public talk, publishing a paper, or explaining an invention in a pitch. Any of these will start the clock on your grace period of 12 months. Please note that this grace period of 12 months is applicable only to the US. If you are interested in filing in other foreign countries, you need to do some research. So some foreign countries do not have a grace period and require absolute novelty, which means that the invention must have been sold or which means that it must have not been sold or disclosed anywhere in the world. So second point is that the utility application must be filed within 12 months of filing the provisional application. It's important to remember this date because the provisional application is never examined by the USPTO. So if you had filed the provisional application to offset costs, keep in mind the deadline, which comes up in 12 months when you are seeking investors or extra funding. Lastly, the patent application takes a very long time. On average, an invention can take from 2 to 3 years until it's granted a patent because there's a pretty big backlog at the USPTO. So if you do need to quicken this process up, you can file your application with the Track 1 request, which is a prioritized examination request for only utility and plant applications. So instead of waiting 15 to 16 months to hear anything back from the patent office, the applicant is guaranteed to hear back within the first 12 months of filing.
So just to sum up, these are some of the distinctions between a trade secret and a patent. Trade secrets don't need prior registration, whereas patents do from the USPTO. The threshold for trade secrets are for secrets that are not readily ascertainable, whereas for patents, there are those 4 hurdles that you must clear. Subject matter that is protectable by a trade secret is more generally the commercially valuable secrets, whereas for patentable subject matter, it is a bit more particular. Trade secrets only protect you from misappropriation, and it doesn't protect you from others who independently acquire the same trade secret or reverse engineer your trade secret, whereas a patent does protect the invention from such occurrences. The duration of the trade secret is for as long as the secret lasts, whereas a patent does have a limit of 20 years and 15 years for design patents specifically. So in some patents do tend to offer a bit more airtight protection than a trade secret, but the trade-off is that it is more difficult to obtain because you do have to jump through a lot more hoops, and it is more expensive, both in terms of cost and time to get one.
So thank you all for joining the presentation today. On the slide, you'll see the website for the Startup Clinic. We encourage you to visit that website, see what we have to offer. And now we'll open the floor for questions if there are any general questions out there. Yeah, all good.
My name is Josh Javor. I had a question here. I'm curious as to if you guys have any opinion or advice on the difference between a patent agent and a patent attorney when you're at early stages of.
Your audio is cutting in and out. I caught the first part.
In the chat.
Okay.
So I guess you're asking the pros and cons between the two, I guess. I'm actually not too familiar with patent agents. Usually in our clinic, we just kind of let our clients know if they want to pursue a patent prosecution that they should kind of contact a patent attorney who is very experienced in the field with just like the formalities and just helping you best protect your invention. So yeah, I'm not too sure if there are any specific differences.
I can jump in here. A patent agent is someone who is not an attorney, but they are able to handle patent prosecutions. Usually a patent agent is working for a law firm and is working under the guidance of a patent attorney. And they are able to help draft patent applications, but they themselves are not actually patent attorneys.
Do we have any more questions? Okay, it sounds like you guys are ready to enjoy your Friday. So if there are no more questions, thank you for joining us, and we hope that you enjoy the rest of your day.